Yes. Yeah, well, so. No, it's right. My parents. We try to fix it this
Great. Good morning and welcome to oral arguments. We're holding oral arguments jointly in docket numbers 210515 RE01, 210515 RE02, and 210515 RE03. So I want to welcome everyone this morning for oral arguments in this matter. I have a couple of administrative items before we begin, including open motion from the Utility Workers Union of America. Is there a representative from the utility workers? If you could please approach the microphone, Mr. Sear. Good morning, sir. This is going to be sort of anticlimactic, just letting you know that your motion is granted. I believe the union filed a motion in RE02, or the motion was filed in RE01. Pura had previously granted the union participant status in RE02. So we are going to extend participant status to the union across all three dockets for clarity of the record for oral argument this morning. We did not receive any objections, so I'm also realizing I didn't really need to bring you out of your seat unless you have anything to say, that the motion's granted.
Thank you.
Thank you. Are there other administrative matters before I do a little bit of housekeeping? Okay, so for housekeeping purposes, we are doing oral arguments across all three dockets. If there is a comment that is specific to one of the decisions, it's helpful for you to note that, but we will consider the exceptions broadly across all three dockets. I know we have a lot of material this morning. We have had an opportunity to read the written exceptions filed by every participant across all three dockets. So we do ask that folks please refrain from summarizing your written exceptions, as we have already read those and they are in the record. The purpose of oral arguments is to receive legal argument across the three dockets. I know we have a number of folks this morning who probably intend to participate that are not lawyers, and that's fine. I do just need to issue a general reminder that we are not accepting new evidence. So the records in all three proceedings are closed, which means that you can make an argument with respect to the evidence that is already on the record in each proceeding. We do 2 rounds for oral arguments. We will take the first round, and then we will allow brief rebuttal for a second round. We have approximately 2 hours this morning, and so we do ask again that you touch on the high points of your arguments and not restate your written exceptions. At this time, it will take appearances. So if you are an attorney representing your client, please approach. If you are a participant not represented by counsel, if the primary person who intends to participate could approach, the microphone should be on just to bring it up a little bit. And if you could enter your appearance, so I make sure to have everyone registered that intends to participate this morning. So I see Attorney Pace who will model this for us, please.
So good morning, Commissioners. Vincent Pace for the Connecticut Light and Power Company, doing business as Eversource Energy.
Thank you.
Good morning, Commissioners. Brendan Vaughn from Keegan Werlen LLP on behalf of the United Illuminating Company.
Thank you.
Good morning, Tom Wheel from the Office of Consumer Counsel. I'm joined by Claire Coleman, Consumer Counsel.
Thank you, Attorney Wheel.
Good morning, Commissioners. Excuse me. This is Jay Goodman of Couch White LLP, appearing on behalf of the Connecticut Industrial Energy Consumers, or CIEC.
Thank you, sir. Attorney Rothenberger.
Good morning, Charles Rothenberger, appearing on behalf of Save the Sound. Thank you.
Thank you. Good morning.
Susanna Nigro on behalf of the Department of Energy and Environmental Protection.
Great. And Mr. Sear, do you intend to offer argument this morning? Not today. Thank you. Anyone else? Okay, well, that should serve as a good order. Attorney Pace, that Brings you up first, please, sir.
So I'm going to start first with some thank yous. And first of all, thank you to the commissioners and the authority staff for all the hard work that was put into this docket and these 3 draft decisions. It's a very impressive amount of work that went into this. And also thank you for reading the briefs and the comments. We saw there were changes between the straw proposals and the 3 draft decisions. So thank you for the attention to our comments. Thank you for addressing some of those. And then finally, thank you for granting oral argument. We appreciate the chance to be here, and consistent with your directive up front, I'm not going to restate all the points we made in our 3 sets of exceptions. I'm here to focus on really the critical points from my client's perspective to allow PBR to be workable. I'm going to start first with the first docket, RE01. I'll spend about 80% of my time on that docket. Then I'll briefly go through RE02 and RE03. Then I'll end with talking about there's still lots of things we don't like in the draft decisions, but we're not pressing those here because our goal is to try and make this workable. We understand it has to be balanced between the needs of customers and the EDCs. So the points I'm emphasizing today from our perspective are critical things that we need to allow PBR to be workable. I'm going to first start with the RE01 docket, which in my mind is the most important docket because it sets out the rate-making framework for the proposed 4-year period. Now, as the commissioners are aware, you know that General Statute 1619 says that at any time, an EDC can come before the authority and submit a rate amendment. And you have to respond within 350 days. So we have that right. It's being used quite frequently. UI filed a rate case in 2022. They came back 2 years later in 2024. That could potentially be the model we continue with. But we understand PBR is intended to offer an alternative. What the PBR framework is saying is that in return for waiving your right to file a rate case, we'd like you to stay out for 4 years. And we understand the purpose is really twofold. First, you want to provide customers with rate stability, and that's understandable. I think we all support that. Second, you want to give the EDC enough time to really challenge itself and drive for efficiencies to try and bring rates down in the future or moderate the size of rate increases. But when my clients looked at the RE01 decision, there were 3 things that jumped out where we said we will not be able to waive the right to file a rate case every 2 years, every 18 months, whatever the time frame will be, unless we can have relief in the following 3 areas. I'll start with the most important issue first, and that is right now, the draft decision says for incremental plant additions, we're not allowed to recover a return, which means the cost that we incur to finance those infrastructure investments, which is a mix of debt and equity, we're not allowed to get a return. We have to wait until the next rate case to get recovery. The concern we have with that is that's just not workable. We incur that real cost to finance those investments, and without that return, we can't commit to a 4-year stay out. I'd like to have Mr. Vaughn now show an exhibit that we provided in figure 1 of our written exceptions, because I think a picture sometimes can tell 1,000 words. So this was filed previously in the record. It was re-shown in the written exceptions. It appears as figure 1 on page 13 of the joint UI Eversource written exceptions in the RE01 docket. And we'll give him a minute to call that up. And thank you, Ms. Lupoli, for calling that up. I appreciate that. So what are we showing you here in this exhibit? So it's entitled Figure 1, and it's referring to the impact of the so-called CT bar mechanism that would provide for incremental funding. Now, the CT bar mechanism only allows for recovery of depreciation, for property tax, and gross earnings tax on the incremental plant additions. As I said before, it does not allow recovery of our cost of finance. And what figure 1 is showing you is that you start from the revenue requirement in UI's 2022 rate case. And it applies the CT bar mechanism to allow for depreciation and property taxes on $60 million of incremental plant additions. Otherwise, it assumes the EDC is running perfectly, that actually the O&M we're incurring is matching what's allowed in rates. And what that shows you is, with all those things being held constant, you see a degradation of the ROE by 155 basis points over the 4-year period. So you're going from an 8.63 ROE in rate year 1 down to 7.08 in rate year 4. With everything being held constant, that's showing you the impact of depriving the EDC of its cost to finance its infrastructure investments. So right out of the gate, there's no opportunity to earn the authorized ROE. And what's also important to keep in mind is, from my experience, rate cases are driven by infrastructure investments. And if we're not receiving a timely opportunity to recover those infrastructure investments, what that means is more frequent rate cases. So that's why this issue is so critical to both EDCs. I'll also point that on behalf of Eversource, data response Q UPA 76 illustrates the same concept, that the CT bar mechanism, by denying recovery of our cost of finance, the infrastructure investments, will not enable us to have the funds we need to run the business, to achieve the goals you want us to in the second PBR docket, and to stay out for 4 years. I'll also point out, in doing my research and preparing for today, there is no statute, there is no court decision that bars PURA from allowing us to recover our cost to finance those infrastructure investments. And if you think about it, the draft decision says for incremental plant additions, the EDC can recover depreciation, property tax, and gross earnings tax. If those can be recovered, then there's no legal bar to recovering the cost to finance those infrastructure investments. I'll also point out that, as some of the people in the room know who have worked on prior rate cases, that type of model was allowed in the 2000s and the 2010s, where we'd come in for a multi-year rate plan. We would identify forecasted plant additions, and we would then be allowed to get a return on those, subject to a prudence review in the next rate case, and also making an annual filing showing what the actual spend was. I also think it's important to take into consideration, when you look at this request, I understand a concern is being raised that what are the ability to contain capital spend? And I'd point out, you have to see these decisions in connection with each other. RE03 points out that if this goes forward, you're implementing the integrated distribution system planning process. It provides additional transparency and oversight over our planning. And that's coupled with the current non-wire solutions framework that provides even more transparency and more input into our planning process. So our view is all those factors coupled together, plus the EDC's commitment that if we don't spend what's in rates, we refund that to customers with interest. And if we're found to be imprudent, we refund that to customers with interest. That provides sufficient safeguards to allow this to go forward. I do want to point out that this topic was talked about by at least 3 other participants in the docket, and I think their comments are noteworthy. I want to spend a minute focusing on those. I want to first turn to the written exceptions that were filed in all 3 dockets by Vote Solar, Conservation Law Foundation, Acadia Center, Systems Smart LLC, Fairfield Forestry Committee, and the Neighborhood Housing Services. It was a combined set of comments. And at page 2, what they say is, if the authority finds it necessary to provide for recovery of the company's return on capital in the CT bar, we would not object to such a change as long as the return on capital is also subject to reimbursement to ratepayers, including carrying costs upon a finding of imprudence. We have no problem with that condition. We're willing to commit to that, but we appreciate their recognition that this is an important issue for the utility companies, and their recognition that if the authority is so willing to grant this request, they have no objection to it. I'd next like to turn to the discussion of this issue and the comments filed by Save the Sound. They submitted written exceptions dated August 15th, and that's in the RE01 docket. I'd like to turn to page 3 of their exceptions. And under subsection G, what they say there is, we raise as a question whether the deferment of prudency reviews for the duration of the multi-year rate plan achieves the broader goal of ensuring rate stability. While holding rates stable in the short term, it may inadvertently lead to larger rate hikes at the start of the next multi-year rate plan. Would holding prudency reviews more frequently avoid the possibility of a large rate increase and the associated rate shock and the going-in rates for the subsequent multi-year rate plan? So I think what Save the Sound is raising there is the question of, if one of your goals is rate stability, if we deprive the utility company of getting that return on investment up until the next 4-year period, what does that mean in terms of the transition from the first to the second multi-year rate plan? What does that mean in terms of rate stability? And wouldn't it be better to have more gradual adjustments during the 4-year period as opposed to waiting until the next 4-year period? So I point that out to express my appreciation for Save the Sound for understanding that by depriving the utility company of that ability to recover its cost of finance infrastructure investments, there's an impact in terms of what the rates could be at the commencement of the next multi-year rate plan. I finally want to mention on this topic the comments submitted by OCC, and I appreciate the exceptions they submitted. So their exceptions dated August 15th, 2025, filed in the RE01 docket, and I'm looking at page 7. Now, it's clear when you read the OCC exceptions in their context, they don't support recovery of our ability to finance infrastructure investments, and they express concern about capital cost containment. However, what I appreciate the fact is they recognize how important this issue is to the EDCs, where on page 7 they say, and I quote, if the authority retains the CT bar and also retains the provision requiring EDC consent in order to establish the MRP, that's the multi-year rate plan, the authority may find itself in a position where the EDC's concerns with the CT bar must, and they emphasize the word must be addressed, or else the multi-year rate plan will never materialize. And so the OCC then goes on to offer some ideas. And what the OCC offers would be, would you allow them to recover perhaps the cost of debt, but not the cost of equity? Would you potentially conduct prudence reviews more frequently? While those solutions will not address the concerns my clients are raising, I appreciate the fact that those 3 participants recognize how big of an issue this is for the EDCs, how it's a complete non-starter for us. And I appreciate the fact that they identified that, they called it out, and they said, are there some things we can do to try to address it? So I wanted to thank them for doing that, and I'll move back into my argument about the other remaining points I want to very briefly make about the RE01 draft decision. The second point that's important to the EDCs is that right now, the draft decision says you're not allowed to recover your rate year plant additions. And when we thought about that and talked about it, we said, but that's what's currently allowed in the current traditional rate case context, in the current rate cases that were recently completed and the ones that are going on now. So if the goal is to incent the utility company to waive the statutory right to file a rate case and to stay out for 4 years, how can you do that if you're saying to them, you get no more than what you're currently getting in a rate case? The rate cases currently are saying to utility companies, you will get your plant additions as of the close of the record. We're not going to grant that for rate year plant additions. So the incentive is not there to abandon the right to file a rate case. And the third point that we have a concern with in the draft decision is it says you're not allowed to recover your known and measurable O&M for the rate year. When I thought about that for a minute, I looked back at the 2022 UI rate case, and I saw that UI actually was allowed in some situations to recover their known and measurable rate year O&M. So in this case, what the draft decision is saying to the EDC, waive your statutory right to file a rate case in return for what we're offering, but actually here we're giving you less than what you can get in a rate case. So again, the incentive is not there to say to the EDC, give up your right to file the rate case in return here on this element for getting something less. So what I come back to is the right to file a rate case is very important to both EDCs. It's not ideal. We understand it creates lots of work for everyone here in this room. And we also understand it does impact the issue of rate stability. But when you compare what we can obtain through a rate case, if we file every 18 months or every 2 years, compared to what the PBR plan is offering us, my clients have said to me loud and clear, we're going to choose to file a rate case every 2 years or more frequently because we're not seeing the benefit that's being provided. We're not getting the revenue stream to be able to stay out for 4 years and actually achieve everything you want us to achieve in the second docket as it relates to PIMs, as it relates to scorecards, as it relates to metrics. So I'm happy to pause there and see if you have any questions about the RE01 decision before I now transition into the second PBR decision, the RE02 decision.
Good afternoon. Thanks, Attorney Pace. So I'm just have 3 questions, pretty much just along the track, how you just presented, so it'll be good. Has the company identified any new or recent Connecticut precedent where carrying charges are permitted on capital additions prior to a prudency review?
What I would point to is, and I brought a copy of it with me, I noticed how you said the word new, but if you beg my indulgence, I'd like to refer to an older case because it's not been overturned. And so the case that I looked at in preparation for that potential question was, I looked at a 2010 rate case decision. It's docket 09-1205. It's application of CLMP to amend its rate schedules. And in that case, the company asked for a 2-year rate plan. And if you look at page 196, it shows you the utility plant in service for rate year 1. And then when you look at page 198, it shows you the plant in service for rate year 2. And the point is it's higher, which shows there was an authorization for incremental plant additions that were allowed to be recovered, in rate base. And so what it demonstrates is the law has not changed since 2010. And as a result of that, we were allowed in that case, and I think other utilities can talk about what was allowed previously, that they were allowed to get their cost to finance those plant additions, subject to making an annual filing that actually demonstrates what they spent, and then subject to a prudence review in the next rate case. And if they're found to be imprudent, those funds with interest are returned to customers. Now, you raised the question of, is there anything more recent that would allow recovery of plant additions with the associated carrying charges? In this case, the cost of finance. And the answer is PURA's more recent rate case decisions have not been allowing that, because I understand your position is that you're not required to do that, but we respectfully disagree. And that's why we have appeals that have been filed of recent rate case decisions, because we do believe that you do have the power. The law has not changed for the rate case decisions I'm referring to. You do have the authority if you elect to exercise it. And I think that's the key question. If you think about it for a moment, and again, I want to go back to the example I gave before. The draft decision is saying that we can recover depreciation. We can recover property taxes. We can recover gross earnings tax on future plant additions. But then it's saying, but you're holding the line on the cost of finance. But that's not a legal distinction. That's a distinction the authority is making because you're not comfortable doing that. So there's a difference between what the law prohibits you from doing versus what you're electing not to do because for policy or other reasons, you're not comfortable currently allowing the cost to finance those future plant additions.
Attorney Pace, I apologize for interrupting. I couldn't write that down fast enough. What was the court case reference, please?
So the decision I was referring to was docket number 09-1205.
So it's a PURA decision.
It's a PURA decision.
It's not a Superior Court or appellate or Supreme Court. It's a PURA decision that presumably was not appealed. Is that correct?
It was a PURA decision, and of course, in a contested case, and it was not appealed. But the point is, it recognizes that the authority has the power to be able to do that. The other authority that I can cite to, which I think is more recent, and it responds to Commissioner Arconte's request for something more recent. It's not a court decision, but I'd actually point to the fact that it's actually something written by PURA itself. And I think it's impactful on this. So what I'm referring to is It's a Supreme Court brief that was filed by PURA in docket number SC 21010. It's Aquarian Water Company of Connecticut versus PURA. And I want to refer to 2 pages in that filing. In that section of the brief, what PURA is referring to is the authority that General Statute 1619 gives to PURA in the rate setting process. And on page 33, what PURA says, and you're actually citing to a Connecticut Supreme Court decision, you say, and when setting rates, PURA can make pragmatic adjustments when needed to achieve a just and reasonable result. You're citing Woodbury Water Company at 174 Connecticut at 264, which is quoting the Hope decision from the US Supreme Court, 320 US at 602. But I think the next quote from the authority is even more persuasive. On page 34 of that brief, what the authority says, and again, this was written in 2024, the authority says through your legal counsel, section 1619, subsection A, which is the general rate case statute, lets PURA allow unsupported capital investments to enter rate base, at least when PURA has not found those investments were imprudent and when necessary to achieve a just and reasonable result. And what you cite to there is your conclusion that you followed that approach in the 2022 UI rate case decision. Why is that important? Because what the authority is saying there is that when there's no evidence of imprudence, you have the discretion to allow rate-based plant additions, which includes the depreciation, the property taxes, the return, and the cost of finance into rate base. And so that's what you relied upon to allow plant additions to be recovered in rate base. And that logic and that legal argument applies here. So I again submit, based on PURA's own statement, the statute does not bar you from allowing a utility company to recover its cost of finance future capital plant additions. And again, the ratepayer protection there is it's subject to a full prudence review. You're not being asked to waive your right to review the prudence. We acknowledge that. You reserve that right. You can exercise that mid-year, or you can exercise that in the next rate case. We also acknowledge if we're found to be imprudent, customers get a full refund with carrying charges. So they're made financially whole. What we are saying, though, is this is a critical must-have because it recognizes for those future plant additions, we have to incur a cost to finance them through a combination of debt and equity. And if you're asking the utilities to waive that statutory right to file a rate case at any time and to get an answer within 350 days, it has to acknowledge that we need recovery of that cost of finance, subject to the protections we talked about. And I think another important protection that's not getting enough attention here is you've spent considerable time developing this IDSP, integrated distribution system planning process, with the stated goal of making sure that you have more comfort and more transparency into our future plant additions. You've also spent a lot of time in docket 240808 developing a comprehensive non-wire solutions program to address the concern about a capital bias, which again gives more transparency and insight into our capital planning process so that we have to look at other options. And if there is a cost-effective solution that addresses reliability, which is non-traditional, we can pursue that. Our understanding was all those things were developed to give all of you and those here in the room more comfort with the decisions we make over what projects to build. So with all those guardrails in place, our request is reasonable. And my point in referring to the Supreme Court brief is that the law does not bar PURA from granting the relief we're looking for. It's a decision by the authority. Do we want PBR to work? Do we want the utilities to stay out for 4 years, to have rate stability for customers, and to encourage them to achieve efficiencies? Or do we want to see rate cases every 2 years? That's the paradigm that we've set up, and we're trying to work, but this is a critical issue for us. So Commissioner Arconti, I hope that's responsive, and I know you had 2 other questions, so I'm happy to respond to the other.
Yep. Beautiful. No, thanks. So second part on going in rates. If the CT bar mechanism is going to provide revenue for capital additions effective at the beginning of that first rate year, then I guess, why would you need the plant additions necessary through rate year one?
I'll have Mr. Horton come up here and supplement my response because that's more of a technical answer. But in spending time with my clients, and I probed on this issue in terms of, is getting the cost of finance in and of itself sufficient? Or do we actually need those rate year plant additions? And the answer I heard from my clients was a resounding yes. We also do need recovery of those rate year plant additions. And I'd like latitude to have Mr. Horton please supplement my response.
Thank you and good morning. I think just to that point is the question based on a premise if the CT bar were adjusted in order to reflect all of the costs, including the cost to attract the capital necessary to make the investments in the CT bar, or is the question as it's designed today, why is the CT bar necessary in addition to having the plant additions in rate year one?
I guess answer as it's designed today.
And so the concern that we have, the flaw that we see is, as Mr. Pace said to the prior responses, right now, and we appreciated this movement in the draft decision from the revised straw proposal, the idea is that we would get a rate case decision and then within 10 days, we would accept or not the PBR plan. But the PBR, the rate year cast off rates based on the revised straw proposal, or excuse me, on the proposed draft decision are designed to be lower than the expected rate case expenses by the reasons that Attorney Pace had laid out, meaning we know going into it that we would only get recognition to any extent of plan additions in the rate year if the CT bar were to be adopted. The going in rates are going to be designed to not include post-test year adjustments for O&M into the rate year or for post-test year adjustments for capital into the rate year. So if the utility is not accepting the CT bar, even though it's designed insufficiently based on the proposed draft decision, then the going in rates, the alternative is also insufficient. In neither case will we have rates that reflect an expectation of our costs to be incurred in the rate year. And then if I might just on the prior response, of course, Attorney Real from a legal perspective is, I'm sure, fully accurate. I think what I would just say, and just to reinforce the point that he made, whether or not PURA has the authority to include the return on equity or the cost of capital in the calculus, I leave it to others to sort out. But again, it's really what Attorney Pace said at the bottom of this, is that if the idea is to have the utilities be able to make a commitment to stay out of a rate case, then the design needs to be such that it gives that utility, and it says this in the proposed decision in a number of places, that it's intended to give the utilities an opportunity but not a guarantee to cover our cost of service, including the cost of capital. And I know this is sort of a rate-making nuance that I'll hammer on. It's not the carrying cost, it's the true cost of capital, meaning that as it's designed right now, the CT bar, the going in rates, the design that's in the PBR proposal doesn't recognize that utilities will incur an incremental cost. So a perfectly executing utility under a PBR framework, the exhibit that Attorney Pace was exhibiting on the screen demonstrates that even a utility who is operating perfectly and spending capital perfectly as designed and tracking its O&M expenses perfectly as allowed for under the PBR plan will see a steadily declining ROE. And that doesn't reflect the fact that PURA itself will have determined the required cost of equity for us to be able to make that incremental investment and to attract the equity capital necessary to make that investment. And that's the flaw that we see. Fundamentally, it's designed in a way that the foundational principles don't give us that opportunity. Whereas if we have a PBR framework that at its face and at its base is designed in that way, that we know even a perfectly executing utility will have that opportunity, that's really what we're after. Because we know that there is no world where a utility is perfect. There's going to be things that come up, that incremental O&M expenses are incurred that don't track perfectly with what the PBR framework allows, et cetera. And so that's the fundamental concern that we have, is putting aside the legal arguments as to whether it's allowable or what have you, just from a practical perspective of being able to accept and wanting to accept and embrace a PBR framework, we won't be able to do it if we don't have, a fair shot at being successful.
And I think you had a third question.
Yeah, it's on RE02, so I'll let you do your thing on on that side then follow.
Thank you for that. And that's a good segue into RE02, and I'll be very brief on RE02. There are 2 points I just want to very briefly emphasize on RE02. The first is, if we don't have the appropriate funding stream, then we can't achieve the reliability and other performance metrics that you've set out. I think we've made that clear in our comments. We'd ask you to please consider that when you look at the request for rate relief we're asking for in the RE01 draft decision written exceptions. And the second is an important point to our engineers and for those who actually plan our system. What they've said is, we're offering a small language change to make sure we can reconcile the SAIDI and SAFE PIM and the CME and SEALID PIM. We want to make sure that we're being consistent with your prior decision in what we call the reliability docket, 17-1203 RE08. To be clear, we're not saying go back and change 17-1203 RE08. What we're saying is we want to commit to infrastructure investments that benefit both CME SEALID and SAIDI SAFE. But when we've exhausted those, we want the latitude to be able to then focus on SAIDI, because SAIDI and SAFE impact all of our customers. I won't go into more detail. It's explained in our exceptions. We ask for a small language change so that we can pursue both. But once both efforts have been looked at and cost-effective measures have been looked at, we'd like the latitude to focus the remainder of our spending on SAIDI and SAFE to benefit all our customers. There are other clarifications we look for in the RE02 written exceptions. I'll rely upon the written submission, and I'll pause here. I'm happy to take Commissioner Arconti's question about the RE02 draft decision.
Thank you. Achievement of PIMS. Does the company see opportunities for O&M expenditures or process improvements to achieve PIMS, or do you view achievement of PIMS primarily through new capital investments?
I'm going to have some of my SMEs come up to answer that in terms of what it takes to be able to achieve some of the PIMS, because the PIMS, focused on SAIDI and SAFE, CME and SEALID, non-wire solutions, and then there was one involving DER interconnections. So I'm going to turn to my bench here and see if any of my clients are willing, if they'd like to share a response. If not, if a client doesn't have a response, we can try and provide that on the second round. Okay, my clients would like some time to think about that, and we'll circle back to you, Commissioner Arconti, on the second round.
Okay,
I'm happy to take any other questions that you may have about RE02.
That was it on RE02. Thanks.
Okay, thank you. For RE03, I want to emphasize 3 key issues. The first is, we get it in terms of the importance of stakeholder input. We saw that loud and clear in the feedback from participants here in this docket and from the authority, and we're willing to work with everyone to ensure that you allow for that stakeholder participation and transparency. But a key point is, on page 26 of the draft, what it says was, at the end of the day, the EDCs have to be open to allowing for changes to the plan from knowledgeable experts and agency staff. The key point I'd like to emphasize is, we're always willing to listen to constructive and good faith ideas to do things better, more cost efficiently. But when the rubber meets the road, it's the EDC that's responsible for keeping the lights on. We're the ones held accountable to those PIMs and those reliability metrics. So we'd like clarification to say, we can consider all these in good faith and try and work with stakeholders, but since we are held accountable for safety and reliability, we should have the ultimate decision, but it's subject to your prudence review, because you can examine if we made reasonable decisions based on what we knew or should have known at the time we made decisions to implement certain capital programs. So we'd like you to please consider a language change there. The second point I'd like to make, and here's where I'm going to ask Ms. Lupoli to show our written exceptions, because we're proposing a change to the process to make it more efficient. I think everybody appreciates efficiency, and what I'd like to please do is turn to attachment 1 to the exceptions that we filed in RE03, and we're going to start with page 3. Okay, that's perfect. And what Ms. Lupoli is showing you there, I'm going to turn to that in my own comments just to walk us through that. Just bear with me a moment. And I want to thank the engineers for the EDCs who put this together, because I think a lot of times a picture says 1,000 words. What they're showing you here is if we follow the literal word of what appears in the draft decision, then it could contemplate a process of up to 59 months. And so what you're seeing here is, first in the green boxes to the very far left, you see the IDSP load forecasting working group and the IDSP joint group. That's a 1-year process. Then you move into the blue boxes as you shift over to the right that are dark blue. That's 8 months for non-wire solutions grid needs and quarterly filing, and non-wires program annual PURA decision. You then in that light blue box spend a year doing RFPs where needed for potential non-wire solutions. Then we move into the green boxes towards the bottom right corner, which are then IDSP solutions and long-term plan working groups, and then IDSP stakeholder education phase, and then IDSP filing, that's another 6 months. Then we have, as we start to now move back towards the left, and the green box for 9 months, IDSP PURA review, and then we have in the orange box a rate case, which is 1 year. If you look in the very far left bottom corner, I know it's hard to read, it tallies all of those. So it says load forecasting and joint working group, 12 months. Non-wire solutions review program, 8 months. Non-wire solution competitive solicitation, 12 months. Long-term plan and stakeholder education, 6 months. IDSP PURA review, 9 months. Rate case, 12 months. What we're offering is we'd like your confirmation that you don't want it to work precisely that way. If we turn to the very next page, what we've said is we can still achieve everything that you want to. We can still do all these steps, but let's do them in parallel path. Let's not have them be done sequentially. And so what we're proposing here for you to consider, and we'd like feedback from others, would be that if we start at the very top of the page, in the green boxes, you see a 1-year process for IDSP load forecasting and working group and joint working group, long-term plan and stakeholder education. Then 6 months for PURA's review of the IDSP, and then to the right there in orange, you see 1 year for the rate case. But what's going on in parallel path here in this revised exhibit is we're showing you that non-wire solutions can go on at the same time as IDSP. Those are the blue boxes you see down at the very bottom. So under this truncated approach, we're still doing everything the authority wants us to do. We're still having the IDSP process. We're still having the non-wire solutions process, but they're not being done sequentially. They're being done at the same time. And the benefit is we're cutting off about 29 months from the first illustration. So all we're saying here is we want to make sure we follow what you want us to do, but we need direction from you in terms of what's the sequencing and how fast or slow do you want the process to move. I think when the OCC gets up, I recall reading in their exceptions, they were seeing it as maybe a 27 or 28 month process. So we're welcome to get input from others about how to make this work, but also to be efficient. So that's what we'd like you to please consider when you look at that part of our written exceptions. Then the last point I'd like to make on the RE03 decision is that the engineers were very clear to me in saying that planning a grid is not a static process. It's a dynamic process. It's always changing. And what they've asked for is just some confirmation that once we snap the line and say, this is what's in the IDSP, they're not foreclosed if there's actually a valid system need from coming to the rate case and saying, at the time we put the IDSP together, this issue wasn't an issue for us. But since that time it's come up, we'd like to put it into the capital plan. It'll be looked at in the rate case. It'll be subject to all the discovery process in the rate case. But what they want assurance of is if they missed the deadline for the IDSP because something comes up later, they're not foreclosed from presenting it to you in a rate case. Because they want to make sure they get it right. They want to make sure that if something comes up, they can be reactive. Because again, we're dealing with a dynamic system. So we'd like you to please consider that request for some reasonable degree of flexibility with those parameters on it.
Attorney Pace, on that point, and apologies if I'm asking you to restate something already offered up in your written exceptions. Do you have a specific standard? So like what comes to mind is we have the regulations around rate cases that allow for amendments within the first 30 days, which isn't exactly what you're suggesting here, but is there some kind of standard or threshold for the how the authority and stakeholders would be assured that this, I don't know what to call it, incremental plant that wasn't identified in the IDSP falls appropriately into that bucket?
Thank you. It's a great question. And our proposed solution would be that when we file the rate case application, we'd have to identify that. So it would be in the pre-filed testimony. It would be in the capital plan we're submitting into the rate case, so people would see that up front. They'd have a chance to ask questions about it. We'll produce witnesses that ask questions. And the natural question is going to be, why wasn't that raised in the IDSP? And we have to have an answer to that. We recognize that. We're not trying to back away from that. We have to explain that. But the key point is, we can't run a system where if we miss the deadline, then options are off the table. If there's a viable option identified after the fact in response to emergent conditions, it should be included in the capital plan we want people to react to and comment on in the rate case.
Thank you.
I think it's a reasonable request.
Understood. So what I heard you say was it would be clearly identified in the pre-filed testimony, which I think is helpful. But the second piece of that, I did hear you say emerging conditions. So is that the standard that you can identify a plant that it was not in your IDSP if it's in response to a condition, an emergent condition or an emerging condition, or
So what I'd like to do is I'd like to consult with my engineers who are here in the audience and respond to that in round two, unless we have an Eversource engineer that wants to come up and respond to it directly. So if we can have Mr. Freeman, please approach. He did participate in this docket, and Mr. Freeman can respond to your question. Thank you.
Thank you.
Good morning. Thank you for the question. So in terms of the incremental needs that might materialize that are not included in the IDSP, these are not limited or even contemplated to be emergent needs. These would be legitimate planning needs that either were not included in the NWA assessment due to timing. And so because they were not included in the NWA assessment, which is the basis for the IDSP, they may not be included in the IDSP, but there could also legitimately be needs that materialize in the time frame after when the IDSP is developed and before the rate case is adjudicated. And so these could be DER-related needs, there could be reliability needs, there could be capacity needs on the distribution feeders. And I say these three because when we look at bulk substation needs, we do have a longer line of sight from the 10-year forecast. On the distribution system, things move a lot quicker. Needs could materialize a lot faster. There are planning needs. They're not necessarily emergent needs, but they're capacity reliability needs that would need a solution. And these are the type of needs that we envision being included in the rate case, but not necessarily presented in the IDSP.
Thank you. That was clear.
Thanks.
So I'm happy to take any final questions on RE03 before I transition to one final point, which refers to all the dockets.
Fine.
Yeah.
I just was going to go back, Commissioner Arconti, to your question and try to just tease it out to make sure that we could respond on the second round or perhaps now. I think your question was, but want to make sure I understood, would the PIMs, in order to avoid a penalty or to achieve an incentive, would we be incurring additional O&M expense or capital expenditures? I guess first, was that the question?
It was more framed around, can you achieve, like, how do you feel like you can achieve those PIMs? Is it through O&M expenditures or efficiencies, et cetera, or is it through new capital funding investments?
Okay, so if that's the case, my colleagues may need to answer. I think that it would depend. I think it would depend on the PIM, our status, and what's causing us to be in either a penalty or a potential opportunity for incentive position. such that we would be making a decision. For instance, I'm thinking like vegetation management is generally an O&M expense. There could be a situation where we're identifying a circuit that could be enhanced, the reliability or safety could be enhanced by vegetation management on that circuit, or there could be a capital expenditure for additional switching or potentially hardening the circuit, which would allow us to achieve the PIM or avoid a penalty. Is that getting at the essence?
Yeah,
of
I
your
guess,
question?
kind of what I'm hearing is situational dependency.
I think
The
that's-
discretion of the company on what's the best way to achieve, what's the best way through spending investment to achieve the desired outcome. Is kind of what I'm hearing in that.
That's how I see it. I think at the end of the day, and the idea of the PBR framework, again, from a financial perspective at least, is to give the company an envelope of revenues to run the system and to do our best to achieve the performance incentives or to avoid penalties, being indifferent as to whether it's capital or expense. And I think that's, again, getting back to the core of a PBR framework as opposed to other frameworks like with capital trackers. You know, there's an argument that the utility in a capital tracker framework is incentivized to invest capital, whereas here there's certainly been a lot made of the different or having equalizing O&M and capital expenditure. So I think in either case, we would be evaluating what's the most efficient, least cost way to achieve the incentive or to avoid a penalty. And I'd imagine that's going to come down to a case-by-case analysis.
Right. So I'm hearing, right, efficiencies, O&M, can all help the companies achieve its PIMs, not just capital alone.
Correct.
Okay.
I see it that way. Yep.
Great. Thanks.
So I'd like to conclude just very briefly with one final point that applies to all three PBR dockets, and that is, you've given me the latitude today to identify what are the critical must-haves my clients are looking for to try and make PBR work and to incent the utility to waive the statutory right to file a rate case. But what I also think is important for context is, while I've focused on those, we should not lose sight of the fact that there's lots of other parts of the PBR decisions that we still don't like, that are still very problematic, but I'm not pressing those because we get it in terms of you need to have a balanced outcome. You need to balance the concerns raised by the Consumer Council, by Save the Sound, by many other participants here, and most importantly, the needs of our customers. So I'll give you just a few quick examples. In the final SAIDI and SAFE PIM that's being proposed in the RE02 draft decision, it's a downside-only PIM. And I argued a number of times in this docket, it should be symmetrical. There should be both upside and downside because we currently have top quartile reliability. It's very expensive to maintain that, much less improvement. And if the goal is to incent us to do better, there should be some upside potential. But the draft decision says, in all due respect, we've heard your arguments on this, it's going to be a downside-only PIM. I'm not pressing that here because I recognize there need to be trade-offs in a regulatory compact where you're balancing all of the different needs of the different stakeholders represented here. Another example would be, whether you believe it or not, this is creating a significant amount of work for the EDCs to implement this. Just focus on the IDSP process alone. I've heard from my clients the number of contractors or incremental FTEs they have to hire. We're not going to complain about the work. We're happy to do it. We're happy to take on the additional workload and do our best in good faith to make it work with all the additional responsibilities that go along with setting up an IDSP and implementing it, as well as tracking and reporting and trying to achieve the PIMs, the scorecards, and the metrics. While we're not complaining about that, the exceptions do point out, to the extent the government, through PURA, is directing us to incur incremental expense, there should be some opportunity to be able to recover that in a timely basis. So if we're hiring contractors, if we're building new IT systems to track and report this information, we should have the chance to be able to identify that to you, to track it, and have you look at the prudence, and if we demonstrate prudence, get some cost recovery. So I appreciate the time you've given me here today to offer Eversource's perspective on the draft decisions. I want to once again thank you for convening this, and also thank you for the hard work that the commissioners and the staff and all the parties devoted to developing the comprehensive draft decisions that we have. I'm happy to take any final questions if you have them for me.
Yeah, I'm sorry. I am going to go back to RE01. I'm just skip
course.
through written exceptions. I just want to follow up on one thing.
Sure.
And that's the known and measurable adjustments through the rate year, which that's the company is in written exceptions, right? You are arguing you would like known and measurable adjustments through the rate year. So I suppose my question is, like, what time period does that, so if the rate year starts on January 1, does the time period cover from January 1 of that year to December 31st? And then how would you, since it's known and measurable, how would you measure that?
We would measure that as, so in the first rate case that we have, where the companies will be setting the cast-off rates, we would propose that whatever is being proposed for rate year 1, whatever that time period would be, if it happens to track a calendar year, or if it happens to track a different 12-month period, that would be the rate year we would identify in the initial rate case application that we submit. And the key point that I'd like to just emphasize there, if I can, Commissioner Alconte, is the thing that concerned me was the draft is saying to us right now that you don't even have a chance to recover that or even seek to try and recover that. And when I looked at, and I'll give you the citation, when I looked at the UI rate case decision in 220808, the 8/25/2023 decision, and we looked at table 42, what it shows there is in a number of situations, if you look at, for example, professional services or customer services, you granted UI O&M for the rate year. So that's something an EDC theoretically has the ability to recover today in a rate case, provided we meet our burden of proof. So I go back to the question of why is the draft decision saying that's currently available to EDCs if you meet your burden of proof in a rate case, but we're not giving that to you in the proposed 4-year PBR period. And how are you incenting a utility to want to stay out from a rate case when they have the chance to get that rate year O&M in a traditional rate case? I hope that's responsive to your question. I'm happy to take any other follow-ups.
I think it was responsive. I think I'll end it there. Appreciate it. Thanks.
Thank you.
Thank you, Attorney Pace. Appreciate that. Attorney Vaughn.
Good morning. Thank you, Chairman Gillette and Vice Chairman Arconti. Brendan Vaughn from Keegan Worland on behalf of United Illuminating. I'm sure you recognize that UI and Eversource filed joint written exceptions, and we did try to focus those joint written exceptions on the key critical issues for both companies to be resolved. A small number of changes in each of the 3 dockets that were critical in order to help the companies move PBR forward in Connecticut. So I won't rehash everything. I think Mr. Pace did an outstanding job of communicating what the key critical issues are in RE01, RE02, and RE03 for each of the 3 companies, or for each of the utilities. We're here in our comments, we're trying to be a collaborative partner to drive the successful implementation of PBR. And we really feel that these changes are necessary in order for PBR to have a chance, and for the companies to be able to, or for UI to be able to agree to a 4-year stay out. So again, I won't rehash the excellent points that Mr. Pace just raised over the past period of time. I will note, I think we echo that in RE01. UI feels that there are sufficient safeguards that have been built in to the RE01 and RE03 framework to provide PURA and other stakeholders with input and transparency into the capital planning process, and into what capital projects are being placed into service. There are downward-only adjustments being contemplated. There is an exhibit that is being required to be filed as part of the IDSP that would document capital investments over $1 million, I believe, in the format of Exhibit UI CIP4, which is a very detailed rate case exhibit that UI put together that supports the prudence of those those capital projects. So we feel that given the level of support and transparency that's being called for and the level of customer protections that have been called for over the 2 dockets, that the authority should feel some degree of solace in that and comfort in the ability to give the companies their full capital costs over the term of the multi-year rate plan, subject to a future prudency review, of course. But there are all those different layers built in. And so really what the companies are asking for is that recovery of capital costs that would allow them the opportunity, but not a guarantee, to earn their authorized ROE, which we've demonstrated through Figure 1 is not currently the case. Commissioner or Vice Chairman Arconti, you raised several questions on RE01, which Mr. Pace did a great job responding to. Again, in addition to the language from Pure's brief cited by Mr. Pace, I would raise the below statement from the recent Supreme Court case ruling in the Aquarian Water Company case, which is 352 Con 381 at pages 390 and 391. And there it says, and this is in response to your question on whether there was new or recent Connecticut precedent on whether you call it carrying charges, I would call it the full capital cost of a project, are permitted on capital additions prior to a prudence review. And this is the Supreme Court described rate making as a prospective endeavor in which PURA makes reasoned estimates about future events to establish a rate that reflects a prospective anticipation of what the rate will be necessary to adequately compensate the utility. And that there are exceptions to the use of a test year in rate making, and that the test year may be adjusted forward for a reasonable period of time to permit the utility to recover definite ascertainable expenses maturing or certain to materialize during that period of time. I would argue that recovery of the full capital costs of the investments put forward in the capital plan and the IDSP meet that standard and would give Pura comfort in the ability to do that as Mr. Pace described. So just one additional point of precedent there.
Sorry, I missed the page.
Sure, I had that at beginning at page 390 and 391. That's the 352 Con 381 citation for that. With respect to RE01, I believe you also had a question on known and measurable adjustments occurring through the rate year. I would echo what Mr. Pace said, that we want to set the O&M expenses based on the known and measurable changes that we identify. We do that currently, right? We use a test year, we put it forward in the rate year, and the authority approves that rate beginning on, for UI's most recent rate case, September 1st, 2023, and we started to recover those costs in the rate year. And I think the goal of the changes that we've identified in RE01 would be to ensure that the cast-off rates are correct and that we have a good opportunity to efficiently operate over the term of the multi-year rate plan and are able to recover the costs subject to those customer protections and can fully engage with PBR. With respect to RE02, I think UI's primary concern is the interplay between RE01 and RE03 and whether the company has adequate funding coming out of the multi-year rate plan established in RE01 such that it can achieve the PIMs, develop the scorecards and the metrics that are required from RE02, and that it has adequate control over the PIMs that relate to reliability and integrated distribution system planning that come out of RE03. So if we're not in control of the solution as the utility and the ultimate entity responsible for providing safe and reliable service, it's difficult for us to see a scenario where we are able to accept like a downward adjustment when maybe the solution that was identified wasn't ours, or if we were forced to implement a solution that doesn't align with what the company has developed. So that's our primary concern, is considering those dockets. There's also certain timeline considerations as far as the filing goes. I won't touch on that. That's set out in our written exceptions, but I did want to raise it here. With respect to costs, I think the companies have proposed a reasonable process to recover the incremental cost. Any incremental cost for RE01, RE02, and RE03, as Mr. Pace described, UI anticipates requiring additional headcount, incremental systems and the like in order to stand up this process that are not currently contemplated in rates and really not currently run the business type costs. We view the RAM as an appropriate place to recover those incremental costs to the extent that they occur. I know Pura has stated in certain draft decisions that it did not feel that these costs were incremental or that they may be de minimis. And I don't know if I necessarily agree with that, but I think that if they were, providing recovery through the RAM would give all parties sort of the opportunity to review those costs in a timely way in an established framework that everyone could see and understand. Commissioner Arconti, you had a question on RE02, which I believe related to the achievement of PIMS and whether the company saw opportunities for O&M expenditures to achieve those PIMS or whether it would be all capital. Paraphrasing you, I think. I believe Mr. Horton touched on this. It would be dependent on the PIM. From UI's perspective, I did speak with Mr. Eves. I think it wouldn't be the prominent tool for safety and safety would be capital investment in order to drive safe and reliable service. But whether it was capital would be conditional, not really. I wouldn't call it discretionary, but I would say it would be conditional based on the requirement, right? So if there were cable faults on a circuit and we need to resolve those cable faults in order to improve our safety and safety scores, that would be a capital expenditure. In the alternative, if it were vegetation management that were identified as the issue driving safety or CME-CLID, that could be O&M. So it would be, I think, conditional on depending on what's driving the issue for safety and CME-CLID. On the DER side, I spoke with Mr. Donnelly, and he feels that the more efficient we become in the process, the better opportunity we would have to achieve that PIM and about streamlining the company's process. So that could be an example of a PIM achievement through O&M expenditures as opposed to capital. So it's not all limited. With respect to RE03, Mr. Pace stressed the need, as outlined in the company's joint written exceptions, for flexibility. Chair Gillette, I believe you had a question on how we would include what I would call like IDSP type projects that were not able to be included in the IDSP for timing purposes. I spoke with Mr. Cruz, who is here from UI, and Mr. Eves, and similar to what Mr. Pace said, we felt that those sorts of projects should be able to be included in the capital plan if they missed out on the need to snap the line for the IDSP 2 years or so in advance of a rate case, right? So just given the timing constraints and how the system planning works, there was a concern expressed by the company's engineers that if a circuit became overloaded after the IDSP was filed or during the working group process such that it was too late to be included in that document, or we get Mr. Eves used the example of some sort of data center decides they want to move into UI's service territory and it's a big new project that requires a lot of system upgrades, that we could include those projects that would have otherwise been in the IDSP but could not have been were not identified at the time through the capital plan. So I think that we would anticipate doing that in the rate case, identifying that in testimony and calling those out to the best of our ability. But as long as we have that confirmation, I think we would feel better about the level of support that we would get through the IDSP and that we weren't leaving projects behind by virtue of trying to snap the line on a process that continues to iterate over time. With respect to RE03 on process and timeline, I believe Pura has called for its review of the IDSP to take place in an uncontested proceeding. And UI, as set forth in the written exceptions, feels that must occur in a contested case. That review, though the IDSP is a planning document and will be used for planning purposes, it also serves as a key input to the rate case. And UI is concerned, as outlined in the written exceptions, that determining, accepting with modification, or rejecting the IDSP in an uncontested case, which then serves as an input to a contested rate case, is contrary to the company's rights, duties, and privileges in efficiently operating the system, and would be akin to sort of prejudging the outcome of what that would look like. So we understand that it's a planning document, but it is also a key input to our ability to stay out of a multi-year, or stay in a multi-year rate plan and accept PBR. And so because it is part of our rate case initial filing, we do think that any review of it that occurs beforehand should come in a contested case. So again, I won't repeat all of the great points made by Mr. Pace. I've tried to move through this with some degree of speed. So UI really does support the goal of implementing a workable and equitable PBR framework. We feel there are myriad customer-facing protections built into the current draft decisions and the current appendices to the draft decisions that set out how PBR should work. We're seeking some degree of balance that would allow the company to recover its capital costs fully and to have its going in rates set correctly such that it can stay out of a rate case, operate efficiently, and provide the benefits to itself and to the administrative efficiencies of not being in for sequential rate cases such that those are realized. And I'm happy to take any questions.
I don't have any questions. I think you anticipated our questions. So thank you.
Thank you.
Who do I have next? Attorney Wheel.
Good morning again, commissioners. Tom Wheel again for the Office of the Consumer Counsel. I'm going to focus most of my comments on the CT bar, but I'm happy to take questions on any other elements that have been brought up today or haven't. I want to first start by agreeing with Attorney Pace that there is no law from our perspective that prevents PURA from allowing the full recovery of the return on forecasted investment. But I also want to remind the authority that there is also no law that compels the authority to do that. I also agree with Attorney Pace that the authority has discretion to balance the interests of investors and ratepayers, and we see that particular element of the CT bar, that is the delayed recovery of the return on investment, as an exercise of that discretion in creating that balance. Attorney Pace also emphasized a statement in our written exceptions that said that PURA may find itself in a position where it must address the EDC's concerns with the CT bar. I just wanted to clarify, that was not meant to be an endorsement of the EDC's concerns with the CT bar. It was rather stating our concern with the structure of the stay-out waiver provision of the draft decision, which from our perspective essentially puts the EDC's, puts PURA in a position where it might have to give the EDCs whatever they demand in order to get a multi-year rate plan implemented. And as we laid out in our exceptions, we don't see that as an ideal provision. And as we've said, I think a couple of times throughout the RE01 proceeding, we don't see why it's necessary to have an agreement or a waiver or anyone give permission to the authority to design a revenue requirement. We think that it's practically possible for there to be a rate case that does implement a multi-year rate plan exactly as worked out in the draft decisions. And if the EDC or any other party has an issue with that, they can exercise their right to appeal. And we do think, I agree with Attorney Pace, that an EDC, according to 1619, can file a request for a rate adjustment at any time. That doesn't mean the authority has to allow a rate adjustment. As we laid out in our exceptions, we do understand that the benefit to ratepayers prospectively of a multi-year rate plan is the cost containment incentive that accompanies it. That if a company is staying out subject to a limited revenue requirement, a pre-established revenue requirement, that incentivizes the company to work within that revenue requirement and find savings. We totally agree with that concept, which is why we have been on board with the multi-year rate plan concept all along. I also acknowledge that what I just said, allowing a situation where a utility can jump in mid multi-year rate plan potentially disrupts that cost containment mechanism. And I get that that's not a perfect scenario, but from our perspective, if if the only mechanism to kind of to fix that problem is to give the EDCs or really any party all of the negotiating power to let the authority know how the revenue requirement is going to be structured according to them, that is a worse case scenario in terms of cost containment and the overall effect on ratepayers.
Attorney Wheel, can I just interrupt? And on that point, can you distinguish for me how the OCC sees the outcome as any different than the authority signing off on a settlement agreement as the draft contemplates it?
Yeah, I mean, I think the distinction is that a settlement agreement is agreed to by all the settling parties, and that there is like a legal hook for the settling for the EDCs typically, if there is a provision in the settlement agreement that includes a stay out, that the EDCs are agreeing to that provision, prospectively, hypothetically, in exchange for whatever other elements are within the settlement agreement that the EDC might not otherwise agree to. I think the main distinction is that mechanism sort of already exists as a legal way to provide for a legally enforceable stay out. But the enforcement hook there is that if the EDC comes in, if it violates the provision of the settlement agreement, then the settling parties themselves potentially have action against the EDCs for violating that agreement. The distinction here would be this would be like a settlement agreement, I suppose, between the EDCs and the authority, but using that as the basis for setting like every revenue requirement in every rate case moving forward, that's our concern, especially because maybe an easier way to say it is in the context of a settlement agreement, like OCC has been party to many settlement agreements, and sometimes we don't agree. Like we'll try to have a discussion about what might work. The EDCs come to us with what they would like, and ultimately, sometimes we say, no thanks, this doesn't work out for us. We don't think we can settle this. The draft decision here doesn't give the authority the ability to say that, I guess, and still end up with a multi-year rate plan. That's our concern. It seems like the structure of this draft decision only lets the authority say, no thanks, we're not in agreement with what the utilities are insisting on, so there just can't be a multi-year rate plan.
I see. But if I can back up, this is helpful. I was trying to read I read the stay out provision as OCC's only true exception. But I was struggling to figure out exactly which part of it was objectionable. So it's not then that the OCC has a concern that its appellate rights have somehow been impinged by the EDC accepting or not accepting the MRP. So
No.
whether it's the OCC or any other party or intervener to the case. So that's not the concern.
No. Well, I mean, I suppose we would still have the right to appeal that decision, but we wouldn't have the basis for that appeal would have to be some legal error in the decision itself, as opposed to the kind of substantive questions that are before the authority in terms of making rates. I mean, I guess to answer that question, I guess I'd have to imagine a hypothetical where the allowance of the multi-year rate plan, I guess a hypothetical where the multi-year rate plan was so detrimental to ratepayers that we would file an appeal, and the basis of that appeal would be that the revenue requirement wasn't just and reasonable, for example. I see that from my perspective, we could still do that under the draft decision, but that doesn't cure our concern, which is that in order for that multi-year rate plan to be established in the first place, the utilities suddenly, after the rate case has been fully litigated, essentially have all this finalized leverage to say, okay, everyone's had their say, but now we get this last say in determining we want this, that, and the other thing before we're going to sign off on this.
Mhm.
So it's, sorry, go ahead.
No, I appreciate that. That's helpful. So it's really that very specific decision point is that you view the stay out provision as drafted, as written up in the draft, as leaving that final decision point to the EDCs and the EDCs alone, and that's ultimately the objection. Is that?
Yes, yeah. I mean, ultimately, as a practical matter, yes, that's
As
the
a-
way we see it.
Okay, so if you just indulge me to try to recollect how we got here, because I think that this is one of the provisions that has evolved through each iteration of the straw proposal. I think an earlier iteration might have approached this slightly differently and just proclaimed that there would be a stay out provision. And I think we received feedback from the EDCs or others, challenging the legality of that. So if everyone, or I guess I shouldn't generalize, if the OCC understands the dilemma that we're trying to solve for, I think what I'm missing is what's the proposed solution if we've tried to come at this a couple different ways and not reached a point of acceptability yet. Is it just that there isn't a solution? And that's kind of where OCC is landed, which is that our answer here is we just have to accept the risk that the EDCs file before the multi-year rate plan is expired.
I suppose, I mean, I think from our perspective, the answer would be to implement a multi-year rate plan revenue requirement and for the authority to say, having evaluated this entire rate case, here's the answer from our perspective. Here's the multi-year rate plan revenue. And I think that EDCs, if, for instance, in rate year 2 decide that that revenue isn't sufficient, they could file a rate case, but in that rate case, they would need to demonstrate that their current and expected escalating revenue according to the multi-year rate plan is insufficient. Again, as I said before, I recognize that ability weakens the cost containment incentive inherent in a multi-year rate plan. But I think that's the answer to the question. That's what we see the solution to the quandary being.
Okay, so if I could just flesh that out a little bit more. I mean, I think there are certain other jurisdictions that I'm familiar with where the commissions do have the ability to just reject a rate case filing made by a utility. I guess I'm asking, practically speaking, what is it that OCC is suggesting? That in this hypothetical, we would be in year 2 of the multi-year rate plan, the EDC makes a filing, and they alleged that their rates are insufficient. What is it that Pure looks at that filing and we make a judgment call that no, they're not? And or do we have to go through the fully litigated 350-day proceeding, which has eroded the benefits of the multi-year rate plan?
I see it practically, I see a solution somewhere between those two things. I think the utility is entitled to notice in a hearing as a matter of the due process clause of the 14th Amendment and the UAPA. But that doesn't mean necessarily that the utility is entitled to the full panoply of due process that they currently get in a rate case. I think the 350-day requirement, for example, is a ceiling, not a floor. I think the authority could decide a rate case in a shorter period of time. I think the utility is entitled, from our perspective, to kind of put on whatever evidence it wants, but ultimately, the level of process that's provided doesn't necessarily need to be the full level that's provided now. That's anticipated to take up the entire statutory requirement.
Okay, so just say this back to you. OCC's proposed solution to the quandary of the stay out provision is that we essentially eliminate the reference to it in the decisions. And there is no binary choice. It's just simply the authority is issuing a decision with a multi-year rate plan, the end. And if we get a filing before the end of that rate plan, we can do a abbreviated adjudicated process or a full one if the evidence warrants it.
Yes.
Okay.
Should I move on to the? Or,
Yeah.
Okay.
Yes, thank you.
I wanted to address Attorney Pace raised a point. I think I don't want to put words in his mouth, but my understanding of what Attorney Pace mentioned was that with respect to forecasted plant additions, the draft decisions essentially don't change the status quo. I was confused by that, especially it reminded me of a statement I saw in UI's, I think UI's brief, again, paraphrasing here, but it said something, as I recall, to the effect of that the CT bar as structured now without the inclusion of the return element is tantamount to receiving no incremental revenue at all. I'm confused by both of these statements because we understand the CT bar to be providing for a revenue source that the utilities have not been provided in the last several rate cases, which would be the return of their investment in the form of depreciation expense, as well as revenue to support property taxes. I just wanted to lay that out there. I'm not sure I understand these repeated statements that the CT bar doesn't make any difference to what the previous rate cases have provided for in the revenue requirement. Again, we see the provision of the partial revenue as a way to address the forecasted plant issue but by balancing the interests of ratepayers and investors. I also wanted to, I think Attorney Vaughn also cited to the recent Aquarian decision, the provision talking about rates being structured prospectively. I agree that that's what the Supreme Court said. That's not new. That's not a new legal standard. That's been a legal standard for hundreds of years, I think, actually, like dating back to like railroad rate cases. But I don't think that isn't a new overriding standard over the used and useful standard. I just want to point out that revenue requirements, even in a single year rate plan that is only evaluating plant in service as of the end of the record, is providing prospective revenue for that plant, where like the revenue requirement is structured to provide the expected depreciation expense and return on that plant as it is incurred in that future rate year. So I just wanted to point out, I don't think that provision of Aquarian changes anything or again conflicts with the used and useful standard. I think maybe though that, to be fair, I think Attorney Vaughn was pointing that out to suggest that standard doesn't prohibit PURA again from providing the kind of solution the EDCs are seeking. I also agree with that. We have in Connecticut, as both EDCs I think raised today, structured multi-year rate plans with both multi-year rate plans and single-year rate plans with forecasted plans in the revenue requirement. It's not our position that those decisions violated any law. But again, as I open my comments with, the authority also wasn't compelled in those instances to provide those revenue requirements either. And I think that kind of leads into the point I wanted to make about Exhibit 1. So what I just said a moment ago about the prospective costs of plant additions that exist at the time of the rate case, the concept here is the concept of rate base, which in my opinion is an entirely separate concept from a balance sheet. So the balance sheet reflects the utility's accounting of its own investments that have entered service or not in any given point in time. The concept of rate base is the proportion of those investments that have been authorized for ratepayer recovery by a regulator. So I think the Aquarian decision also supports this concept that the kind of central dispute in that case regarded the disallowance of plants, the authority's disallowance of certain plant investments to enter rate base. And the Supreme Court upheld the authority's decision there and pretty clearly from my perspective highlighted that ultimately the investments that go into rate base are at the discretion of the authority, of course, pursuant to its statutory mandates. But that, I guess, simply put, just because a utility invests capital in infrastructure doesn't mean that that is rate base. It's only rate base once PURA authorizes it. And that brings me to my criticism of Exhibit 1. What Exhibit 1 is showing is escalating annual rate base based on the expenditures, the plant additions the company expects to make related to the CT bar, and shows a diminishing return on that, what the utilities are framing as rate base. And the statement that the utilities are making is that that demonstrates an inability to earn their authorized return. I disagree. I think the authorized return on equity is the proportion of the equity investment of authorized rate base that should be incorporated into the revenue requirement. So the demonstration that, like, well, hey, if we invest more and PURA hasn't conducted a prudence review and hasn't actually authorized these investments to enter rate base, if we're not getting escalating revenues to increase our return on these investments that we are making without PURA's full review, that's somehow depriving us of our right to earn our authorized return. Again, I disagree. That's the right to the authorized return is the right to the return on authorized rate base. I think I'll end. Oh, a couple more things. I apologize. Attorney Vaughn referenced the incremental costs that the companies will incur in order to facilitate, I think, all of the various components of the 3 PBR decisions, and proposed that those costs should be recovered through the RAM. We wholeheartedly disagree with that perspective. We don't disagree that there will be incremental costs, but these costs, from our perspective, are solidly operational costs that are part of the utilities' bread and butter baseline business model, which that is what base rate O&M is. And I think the suggestion that these costs, like other costs, which we also continue to question already being in the RAM, that from our perspective should be in base rates, the suggestion that, oh, this is going to cost us more money, so we need to reconcile, to annually reconcile these costs to actual expenses and eliminate all risk associated with them being put into base rates. We thoroughly object to that notion. The appropriate treatment would be for the company to come in during its rate case and demonstrate the incremental costs it has incurred or will incur in the rate year, and ask for an adjustment to base rate O&M to reflect those. I just wanted to conclude that we and a lot of other interveners and the utilities, and certainly perhaps most of all, the authority has put a lot of work into these dockets over the last more than 3 years. We think that work is highly valuable, but we also view these dockets as being uncontested dockets and these final decisions as being final decisions in uncontested dockets. And that what we've all been working on here from our perspective is creating the lens through which future rate cases will be viewed. And we don't see the elements. I think we're a little confused reading all of the utilities exceptions, which seem to be interpreting all of these draft decisions as being kind of black and white, hard letter, hard line rules for what is and isn't allowed to be discussed in a rate case. That's not our understanding of what the intent of the authority is, or our understanding of what the conversations have been all this time. So for instance, the utilities request today that that they be allowed to address projects that weren't part of the IDSP in the rate case. We wholeheartedly agree. As we've been saying all along, we think the IDSP should be informative in the rate case, but we don't see it as a structured, pre-established kind of formulaic input into the revenue requirement. That's not, from our perspective, the purpose of the IDSP. And I think that's true of a lot of the concerns that we saw across the utilities exceptions seem to be based on this idea that once these final decisions are issued, that's it, and there's no this is the entire scope of what's sort of allowed to be discussed or analyzed in future rate cases. Again, we don't see that that's been the purpose of these proceedings all along. So I just wanted to conclude with that point. And then, unless there are any further questions, that's all we have.
Thank you. Attorney Goodman?
Good morning and thank you. Jay Goodman of Couchwhite LLP, appearing for CIEC. Although CIC also has multiple concerns remaining regarding the PBR proposals, wanted to just focus specifically on one today. And in the interest of not repeating comments already filed, I'll just jump right into the middle of it. And this specifically relates to the incremental cost to implement PBR, which we've already heard from multiple parties about today, and the fact that, to my knowledge at least, there has been no estimate entered into the record yet as to what those implementation costs are. CIEC understands that in the IDSP proposed final decision that the authority issued recently, the authority expressed one concern that pausing the process now to develop and consider those estimates could further delay the implementation of something that's been in development for multiple years. And we understand that, but think that it's possible even that, given that the final decisions are scheduled to be issued on around October 8th, that there still may be enough time for the utilities to submit into the record an estimate of what their implementation costs may be. And if that's not enough time, then perhaps with the first IDSP filing, any of the initial PBR implementation filings may be coming out, IDSP and others, to provide those estimates so that there's some understanding of what the implementation cost will be hopefully before the utilities really start to incur those costs. CIC understands the authority's anticipation that any cost to implement PBR will be modest or otherwise immaterial. Directing the EDCs to provide their estimates and considering that, simply could confirm that expectation. Or if not, I think it would be helpful for the authority and other parties to understand what the potential rate impact of these decisions will be. It's possible that even if it's not immaterial, it will be relatively small in nature, or it is also possible that it actually would result in a more material rate increase. And we've heard today from the utilities, in addition to the previous filings that they've made, that they anticipate, needing to increase headcount by, I believe, an as yet indeterminate number of FTEs, as well as potentially invest in additional changes to or new systems and software, IT system changes, among other expenses and investments. So again, we would submit that at a minimum, the EDC should be required still to submit an estimate of what those costs will be at the earliest possible date, and would submit that given how deliberate the authority has been with development of PBR across several dockets, several years, and numerous technical meetings and opportunities for stakeholder input, and also given that affordable service is one of the priority outcomes adopted for PBR, that it's difficult to understand why the authority would not also want to evaluate what the potential cost to implement its PBR proposals would be. And again, think that the risk of failing to consider those estimates is that the EDCs may be committed to a course of action that would result in a material rate increase, where that should have been known before the decision ultimately was made. We're not saying that if there is a rate impact that you should shelve PBR. It's just if it were to be a material amount, you may want to consider different ways to potentially phase certain aspects of it, try to moderate what that impact is. We consider this step that we're recommending to be a basic part of due diligence in terms of developing and implementing PBR. And also that it's necessary to ensure that rates remain just and reasonable. Final comment on this point is that, we agree that to the extent that the utilities incur, prudent costs to implement PBR, they should be entitled to recover those costs. However, CIC agrees fully with the position expressed by Attorney Wheel and OCC, disagrees with the utilities that the appropriate way to recover those costs would be through base distribution rates and not the RAM. As Attorney Wheel said, PBR, or I'll paraphrase, PBR, I believe, is intended to change aspects of the way that or many aspects of the way utilities conduct business. These costs will be essentially the cost of doing business, and those expenses and investments typically are recovered through rates. And that's how we think this should be handled as well. I'd like to make one final point responding to something expressed, we think, very well by Attorney Pace and also echoed by Attorney Vaughn. This relates to the IDSP. And we agree that it's important for the utilities to retain discretion to make changes to any approved capital plan in response to emergent system needs or otherwise. My understanding is that the utilities generally in various jurisdictions will develop a multi-year capital plan that they work towards. However, given that the system is dynamic, as Attorney Pace said, there is a regular need for the utilities to reevaluate the prioritization of certain projects and move things around in order to stay within approved budgets, but still meet the needs of the system. We think it's very important that whatever the final design of the IDSP and the PBR as a whole is that the utilities need to retain that discretion to have the final say on the projects that are needed to maintain reliability on their system, and would be very concerned if the utilities' hands are tied in a way that would prevent them from being more nimble in response to emergent needs. We agree that the presumable requirement for the utilities subsequently, if that's what is needed, to explain and justify the change should protect customers adequately, because there still would be an opportunity to review for prudence and potentially disallow investments if the authority ultimately decided that the utility should not have decided to change, to kind of change course, as it were, during the capital plan. That's all I have to say now, but I'm happy to answer questions if there are any.
No questions. Thank you.
Thank you.
Attorney Rothenberger.
Thank you, commissioners. For the record, Charles Rothenberger with Save the Sound. I'll be really brief. Don't feel the need to necessarily rebut anything that was said during this morning's session. I was really here just to emphasize the fact that the authority is operating under a strong legislative mandate to design and implement the PBR framework. In our view, and I don't believe I heard anybody argue to the contrary today, each track of the PBR framework really stands alone. There are some interrelationships, certainly. We heard a lot of discussion about the IDSP and how that operates as an input, one input into the CT bar mechanism under the revenue adjustment mechanism. However, regardless of the position that the EDCs may take with respect to the adequacy of the cost recovery mechanisms under the RE01 framework, it doesn't impact the validity of the performance measures developed in RE02 or the importance of developing the IDSP as designed in RE03. So we just wanted to underscore the fact that the overall framework developed across these three dockets do not necessarily fall or rise together. And if the EDCs moving forward decide that they're going to pursue a more traditional rate case to recover their costs outside of the revenue adjustment mechanisms, we don't think that would be ideal, but that does not necessarily invalidate or relieve them of obligations under the other dockets. So I think that's all I wanted to say for the record. I'm happy to answer any questions you may have.
No questions. Thank you.
Thank you.
Attorney Nigro, please. Thank you. Did I miss anyone in round one? Okay, then we will return for brief rebuttals, please. Attorney Pace.
Thank you. I'll start with the question that Commissioner Arconti raised, and I asked for permission to consult with my clients during the break. And your question was, when the company's looking at the PIMs, specifically the SAIDI-SAFI PIM, the CME-SEALID PIM, and the non-wire solutions PIM, is it more capital intensive or O&M intensive to be able to achieve those results? And the answer I received was, it depends. There are O&M solution and capital solutions to both. And so we have those tools in our toolbox, and we'll have to make a decision about what's most cost effective, what's most prudent at that time to be able to solve for that particular problem. So we're not trying to evade the question, but the engineers want to reserve the right to look at the facts with the issues they're dealing with and decide what is the most cost-effective approach to be able to achieve the result you're encouraging us to achieve. I want to next turn to some comments made by the Consumer Council. I want to thank Attorney Wheel for acknowledging that the law does not bar PURA from granting the relief that we're looking for. I think you have consensus here in the room that there is no statute, there is no court decision that says PURA is barred from providing the utilities with recovery their costs to finance future capital plant additions, nor is PURA barred from authorizing, if we meet our burden of proof, recovery of rate year plant additions, and then also, if we meet our burden of proof, rate year O&M. What I also heard no one object to is, I started by focusing on the fact that from my experience, from my client's experience, it's capital investment that drives rate cases. And it's the inability to get timely cost recovery that drives rate cases. CLMP currently has a capital tracker, which has enabled the company to not come in for a rate case. But with the expiration of that capital tracker pursuant to legislation, we find ourselves with two choices: to accept the multi-year rate plan offered by PBR, or to come in for rate cases every 2 years or more frequently. And the point we'd like to make is, knowing that capital is such an important part of our business, and knowing that that drives rate cases, the question we pose to the authority is, right now, the RE01 draft decision does not give the business sufficient revenue to stay out for 4 years. We're trying to find a way to make it work, but the numbers simply do not add up. So we'd ask you to please think about, is there the possibility you have the power to grant this relief, and we believe we've offered sufficient justification for it, and we've also identified protections for customers. Let's point those out because they're important. We're subject to prudence review. You're not waiving that. If we're found to be imprudent, we give the money back with carrying charges. We make no concerns, or we have no objections to that. And we want to be held accountable, but we need sufficient revenue to be able to stay out for 4 years and achieve all the goals you've set out for us in the RE02 docket. You want us to maintain and improve reliability. That's going to be expensive to be able to do that when we're currently we're currently top quartile in reliability. What I also want to turn to now is Attorney Wheel spent some time responding to some good questions from the chairman about the stay out provision. And I'd like a chance to respond to the chairman's questions about that. I think right now the draft has it right, because what the draft says is at the conclusion of the initial rate case that's setting the cast-off rates, you approach the EDC and you want an answer. And that is, are you willing to accept the 4-year PBR plan or a 1-year rate plan and not obtain some of the benefits you're purporting to offer in PBR? I think parties need that clarity right up front. And I know the OCC expressed concern about not wanting to give the EDC leverage. You're not giving us leverage. I think the better way to look at it is you're acknowledging what the law currently provides for. If you read the PBR statute, which I know you have, it doesn't amend 1619 subsection A. 1619A, as we talked about, says at any time an EDC can file an application to amend rates, and PURA has to respond with your answer within 350 days. So that's not impacted. And so the benefit of your current approach is you get that answer up front. If you were to change the draft decision, and if you were to say, regardless of what the EDC thinks, we're going to order a 4-year rate plan under PBR, then in that situation, counsel for the company sits down with the company and says, do we file an appeal? I think an appeal is very likely, but then also you have to expect that at some point down the road during that 4-year period, could be 1 year, could be 18 months, could be 2 years, you're going to see another application to amend rates. And isn't it better for everyone involved, including the authority, to have that knowledge right up front, to know whether or not the EDC is going to agree to waive the right to file a rate case and accept the 4-year PBR plan, or if it's going to go for the one-year plan and reserve the right to file future rate cases. I think clarity, I think certainty benefits everybody. And so therefore, I would support the current treatment you have on the stay-out issue in the draft decision.
Attorney Pace, on that point, on the waiver question, is your client's read of the draft of this issue as it's described in the draft, that they are waiving the right to file a rate case no matter what, or is it conditioned, or I just want to make sure that we all understand exactly the words on the paper. So maybe if you could just explain what your client's understanding of the draft as written says on that waiver point.
Our understanding, and we'd appreciate any clarification if you disagree with the interpretation, is that you're looking for the EDC to provide you with an answer within 10 days to do one of two things: to either accept the 4-year rate plan with a stay out that's offered under PBR with the CT bar and with the ability to come in for exogenous factors if they meet the 0.75% threshold, or it's to have a traditional 1-year revenue requirement for rate year 1, and the utility can elect to then come in at any point in the future during that 4-year period and file a new application to amend rates. That's how we read the language, but if we're misinterpreting that, I'd appreciate further direction from the authority. And I think if that's the case, that benefits everyone because you're getting some clarity in terms of what our position is on what's been being proposed in the rate case.
I appreciate that. I think something, I may have misheard you or didn't understand, but I thought I heard you to suggest that the EDC would never waive their right to filing a rate case. So like, I just wanted to make clear, if was that statement meant to be, if Pura doesn't address our written exceptions, we won't do that.
Correct.
Okay, because how it came across, or how I understood it just now, was like there is never a situation in which the EDC would waive its right to file. So what you're instead saying is that the EDC would waive its right if its exceptions were addressed, or some version of that. Please clarify.
Yes, and thank you for the chance. And so when I did say not waive, what I meant was, unless the multi-year rate plan addresses the concerns we've raised about our cost of finance capital plant additions, the rate year 1 plant additions, and rate year 1 O&M, we would not be in a position to forego our right to file a rate case during the 4-year period. But if there is a sufficient revenue stream to be able to run the business and do all the things you want us to do and maintain safe and reliable service, then the company should be asked to commit to provide the certainty that you're looking for and the rate stability you're looking for a 4-year period for customers.
Okay, so said another way, if there is an acceptance by the EDC of an MRP, which presumes that Pura has addressed whatever concerns there are, or rendered an MRP that the company can live with, if the company has accepted the MRP, they have also waived their right to file a rate case during the tenure of that MRP.
That would be my expectation. And again, it's going to be contingent upon the results that are achieved at the outcome of that rate case and an assessment of, does it address the concerns and achieve the balance we're hoping for in terms of balancing EDC and customer interests. The EDC would be asked to make that decision, that you forego the right to file a rate case during a 4-year period if you conclude that those terms are sufficient to allow you to run the business, do all the things you want us to do, and provide a reasonable opportunity to give a return to our equity investors. And if our conclusion is that's not been satisfied, I think it's better for everyone to know right up front that we're not accepting the 4-year plan and we're going to reserve the right to file a rate case. So again, I think it's not a leverage issue, it's an acknowledgement that the statute allows for that. It's better to be able to have the certainty right up front. The alternative presented was order the EDC to follow a 4-year plan and then wait for an appeal and wait for a rate case to be filed while the appeal is pending. I think that that just creates uncertainty, and I would recommend that we all would like to have greater certainty over what the future would be for the 4-year period.
Thank you. I'm clear on that point, but the related point, I guess, that we haven't touched on yet is, do you view acceptance of the MRP as a waiver of the company's right to appeal the rate case decision? Or is there a scenario in which the company appeals the MRP decision while accepting the MRP?
I appreciate your point, which is you're trying to understand to what extent could a sufficient and reasonable 4-year multi-year rate plan provide certainty to all parties in terms of no new rate case and no appeal. And the reason why you hear me hesitating, of course, is I'm being asked to respond to a hypothetical. And so if we assume in your hypothetical that the rate case yields a just and reasonable result, that we receive the revenues that we requested to be able to achieve all the goals that we've identified, then the expectation would be, why would the utility file an appeal if it deems that 4-year rate plan to be acceptable? But I want to caveat it by saying we need to see what the actual results are. There's no way that I can sign off on a yet to be decided rate case. I can respond to that conceptually by saying, if the reasonable needs of the EDC are addressed, then why would the EDC then seek to have an appeal?
Sure, and I think you hit it on exactly what my area of concern is, or what I'm trying to flesh out. Like, you're identifying, I hear, not to oversimplify it, but I hear two, sides of this issue, OCC's points and then the one you're raising, and it seems to be the pro, as I understand it, from the EDC's position in favor of leaving the stay out provision intact as articulated in the draft, seems to revolve around the benefits associated with certainty. And so I'm trying to test the bounds of that certainty. Like, what are we getting from that certainty? And it sounds like your position is that this is too speculative, that you can't commit on behalf of your client to say that acceptance of an MRP also translates into an agreement that there will not be an appeal of that MRP decision.
And I hope you can respect my position, which is that the reason why, as legal counsel to the company, I can't commit in advance is we have to see what that looks like. But I do think it is fair, because I want to try and be responsive to your question, to say that if the authority has addressed the valid concerns that are being raised about having an adequate revenue stream, and if it addresses the concerns about rate year plant additions, rate year O&M, and also the ability to recover the cost of capital to finance those future plant additions, then I think the expectation would be there's a lower probability of the utility filing the appeal. But nobody can make any guarantees, because we're talking about we have to actually see the results. And you can appreciate my position, which is I have to see what the final decision says before I can sit down with a client and decide that we file an appeal or not.
Mm-hmm. I do appreciate the position, but now I'm trying to understand the inverse. So why would you not just accept the MRP decision and appeal? Like, if there's something in the MRP, so if we have that binary choice between the 1-year rate plan and the MRP, and there's something in that MRP that is causing you concern, but you're preserving your right to appeal, I guess I'm not clear why we wouldn't just accept the MRP subject to whatever the court says on appeal. How are we in any different of a situation? And I think that's what I'm trying to test, is the inverse of that situation.
I still think in my view, for the reasons I mentioned, you're obtaining greater certainty for everyone involved in terms of what the EDC's position is if you keep the current language. But if you decide to change it, you decide to respond to the concern raised by Attorney Wheel, then what you have to be prepared for as a commission and as a group of stakeholders here is for an appeal to be filed potentially, and then for a rate case to be filed at some point, or 2 rate cases to be filed during the 4-year period. So it's a question of, wouldn't you have greater certainty up front? And that's a judgment call the commission has to make. I know it's not an easy decision to make, but our view would be it's better to know upfront and have greater certainty. And I realize the OCC respectfully disagrees, and I appreciate the points that Attorney Wheel offered for your consideration on that.
Thank you.
I also want to express agreement with OCC that Attorney Wheel said that he's looking for assurance that the details of PBR, and in particular the PIMs, will be implemented in the rate case. We agree with that. We agree that you need some level of flexibility to tailor these to the specific facts you find in the rate case, and we recognize that. I wanted to very briefly respond to two comments made by Attorney Goodman on behalf of CIEC. He inquired about what's the estimate of the incremental systems, contractors, and FTEs we would have to hire to implement the integrated distribution system planning process and to track on and report the PIMS, scorecards, and metrics. If you want us to provide an estimate, we're happy to do that. So if you want that, you can order that. We'll do our best to get you the information. So that's a fair request, and we can do our best to get you the best information we have. I also lastly wanted to respond to Attorney Goodman's question about where do you recover those expenses. So there's agreement that you can recover those, or you can seek permission to recover those if you meet your burden of proof that they're truly incremental and that you've engaged in prudent procurement of new systems and also contractors and FTEs. So we agree that you can raise it in the rate case. I think the open issue is what happens for the time up to the rate case. What you heard Attorney Vaughn and myself propose in our exceptions would be we'd be allowed to raise it for review in the RAM docket, and you heard OCC and CIEC say absolutely not. It's our position that these are government-imposed costs resulting from compliance with a governmental order, and if we can demonstrate they truly are incremental, and if we meet our burden of proof, we should have an opportunity to request recovery before the rate case. So I realize they disagree. I'm not going to change their minds, but that's the perspective of the EDCs, which is there's but-for causation. We're being told to stand up an IDSP process. We will do that, but we have to hire FTEs or contractors to do that. We're being told to track certain things. We will do that, but we may need systems to be able to do that. As long as we can show they're incremental, as long as we can show they're directly resulting from compliance with your order, we think it's reasonable to say you have a chance to seek recovery if we meet our burden of proof.
Attorney Pace, I appreciate your attempt to respond to that, but it feels a little bit like an exception that swallows the rule. How can you distinguish between the situation in which PURA has directed the company to comply with an order and anything else that is the subject of having to comply with a regulatory order? Wouldn't the definition that you just offered mean that any compliance with the PURA directive could be recovered through the RAM?
So one way that we can distinguish that would be, I think there's consensus that over the past 3 years we've spent in this docket, we're working on something here that's monumental. It's a significant change in the way that we're running our business and we're interacting with the stakeholders in PURA. This is not some comparatively small docket imposing some minor obligations. This is a sea change in the way that you're conducting rate making and the way you're going to be involved with capital planning. And so to me, it's an issue of materiality and significance. Clearly, this is a significant docket with material new obligations. And that distinguishes that from lots of other decisions that we deal with from day to day where you ask the company to be able to take on additional responsibilities. And we're not backing away from the obligation to show it's incremental. We understand that. If it's being recovered in base rates, we're not going to seek to recover that. But if we can show in the record that there's a but-for connection, it truly is incremental, we should have an opportunity to present to you a request for cost recovery. I'm happy to take any other questions. That concludes my response.
Thank you very much.
Thank you.
Attorney Vaughn.
Thank you. Again, I would echo in agreement with much of what Attorney Pace said in response to the OCC, CIEC, and others. I believe I'll make one additional point that Attorney Pace did not make. I think OCC included some discussion of the company's UI's brief in which it said that that the CT bar mechanism was tantamount to failing to include any, I think Attorney Wheel paraphrased and said incremental revenue or incremental funding. And that does come from pages 66 and 67 of UI's brief. But the discussion of it was in the context of, it says, tantamount to failing to include any incremental capital funding at all, as the construct contemplated in the revised straw proposal means that any dollar the utility invests above the level of depreciation expense would suppress its earned return. So I think there's a little bit of nuance there. We weren't saying that it did not provide for any revenue, but we were saying that the way that it was structured mechanically without any return would cause the company's earned return to erode over time if it invested above the level of depreciation. With respect to, I wholeheartedly agree with what Attorney Pace just stated about compliance with pure directives and the difference between this and a regular compliance filing that says, give us, X report. We're here, we're standing up new systems, we're needing to hire new people. There's a detailed stakeholder process that will require new FTEs. I think that's a level of materiality, as Attorney Pace said, that is different from your normal run the business expense. And I think eventually it could become or will become a run the business expense once we have a litigated rate case, but that does, those costs could be included in distribution rates moving forward after we've stood them up. But there is a level of cost recovery that will be, or a level of cost that will be required to be incurred before that happens. And I think that the proposal we've offered is a reasonable path forward to provide that cost recovery, give us that support so that we can implement these pure directives that are incremental to our run the business costs. And with respect to what Attorney Goodman asked for as far as a cost estimate, I don't believe that any one discrete estimate has been provided by UI in the record. We did indicate the need for several additional FTEs with respect to standing up the stakeholder process and certain of the compliance reportings in RE03. We could work to put together a more comprehensive cost estimate should one be required. But other than that, I will fully support the comments raised by Attorney Pace in response to the OCC and CIEC. And if you have any questions, I'm happy to address them.
I don't have any additional questions, and I just want to make sure that your last comment in which you echoed Attorney Pace means that you don't disagree with the responses he provided to my questions about appellate rights and the stay out provision.
Correct. I do not agree that we could hypothetically agree to waive our appellate rights. I understand that the conflict there as far as looking for it. But the stay out provision I think is important, but I do agree that it would be those would have to be evaluated on a case by case basis to see what the decision says and what legal rights may be implicated, and those would have to be protected if necessary.
Okay, thank you. So nothing further to add to help distinguish between why we wouldn't just select the multi-year rate plan and appeal it if we weren't happy with it. If you're gonna still appeal it, even if you are more happy. I'm just really struggling with, apologies. The question had come to me in the moment when Attorney Pace was talking, so it's not well formed. But I'm trying to understand the benefit around the alleged certainty that comes with accepting that stay out provision. And I just am really struggling to understand the distinction between if you have a multi-year rate plan that you're more happy than not with, so you take it, but you still appeal it. I'm just not sure what the distinction is between that scenario and just accepting the multi-year rate plan and appealing it when you're less happy with it. Because if you're appealing, you believe you have a case, you believe that PBR has made an error. So presumably you think you're more likely than not going to prevail on appeals. I'm just trying to understand what alleged incremental certainty PURA gets in that situation.
And I apologize for the pause. I'm just trying to process your question and see if I can add to what Attorney Pace said. So I viewed the stay-out provision, which we appreciated, as being added in response to some of the EDC comments about how we could not see into the future and agree at the outset of a rate case that we're just going to accept a multi-year rate plan. We just don't know what the outcome is going to be. And so that provision was, I believe, added in response to some of those comments. You know, we, as Attorney Pace and Attorney Wheel, have indicated, you know, we do have a right to file a rate case. And so what we were trying to convey is that, and I think what the PURA was trying to do with the stay-out provision was saying, okay, we understand that you can't agree to it at the outset and just say you're going to file for you know, the PBR plan type that we've described here, and you're going to accept it, and then you're not going to file again. So you need to review it and then respond with the stay-out provision. I think that whether or not the stay-out provision is accepted is going to be entirely dependent on the structure of the rate case, right? The structure of the outcome of the rate case, which was the point we were trying to make moving, you know, back in our comments. Appeals can, you know, appeals are necessary to take when the company's legal rights are, you know, impinged, or the company feels that it needs to make its legal case to the Superior Court. So I don't believe that we can respectively waive that, but you could see a situation where the multi-year rate plan, if structured correctly at the outcome, you know, and we've all gone through the rate case and there are, you know, the decision comes out, and I'm sure there are adjustments that PURA makes that the company maybe doesn't like, and maybe adjustments that the OCC doesn't like. But we reach a litigated outcome and the company determines that it works, but it agrees to it, but you know, an appeal is necessary to preserve some sort of appellate right. I don't see that as being inconsistent with the PBR framework. I think that the concern we were having is that if the structure just didn't work, that we wouldn't accept the stay out and we would just file another rate case. I don't know if that's addressing your question, but I think that there's a distinction between the need to appeal in order to preserve one's legal rights and the ability to operate under the framework.
Thank you. Appreciate that. All set. All set. Thank you. Attorney Wheel.
Thank you, Tom Wheel, for OCC again. A couple of points. Attorney Pace brought up the fact that at least Eversource has a capital tracker in place right now that is legislatively required to sunset at its next rate case. I just wanted to point out that the draft decisions as we read them, the draft decision of RE01 on page 40 allows for the implementation of new capital trackers for both companies. So I'm not sure, and we've supported throughout this proceeding the consideration of capital trackers, in fact, over the CT bar. So as we read the draft decisions, there's the potential for there to be both a CT bar and a capital tracker. I just wanted to point that out, that I'm not sure I understand the argument that the expiration of the ESI is somehow means that there has to be a CT bar structured exactly as the utilities insist, given the potential for a new tracker. I also really wanted to address, Attorney Pace made the point that the stay-out waiver lets everyone know right away sort of what the utilities will do, and there's some value to that. And I respectfully disagree. I see that as a false equivalency. And I don't want to suggest, what I'm about to say is not based on the expectation of any particular company. I just want to talk about sort of the incentive structures that are being set up here as I see them. Again, this is not meant to suggest that like a certain company will behave a certain way, but under the waiver structure, the incentive as I see it is for the utility to withhold its waiver unless and until it gets every element that it's seeking in the rate case. It has the incentive right there and then to say, well, we're not going to waive unless we get this, that, and the other thing. And I think that's a different decision structure in that moment than the decision the utility would have to make in the future, getting a revenue requirement that it isn't 100% happy with and existing in real life under that revenue requirement and making a decision about whether it must file a rate case now. And I hope I'm clear on that. I think it's not the same. I think the suggestion that the utility will broadcast to everyone in real time what it will do in the future under the context of the waiver requirement, that just from an economic incentive perspective isn't the same decision. And I think history shows us that. I think that if the authority goes back in time over the last 30 years and looks at every litigated distribution rate case in memory, at least from what I've seen, every single one of those cases I've ever looked at starts with a utility requesting a revenue requirement and advocating throughout that proceeding that is the absolute, that revenue requirement is the absolute minimum that's necessary. That is sufficient, but no more than sufficient to provide the utility with the revenue it needs in order to operate. And in almost every single one of those cases, the utility is ultimately authorized something less than that. It's actually pretty rare that PURA or the DPUC before it, in a fully litigated case, awarded the utility the revenue requirement that it insisted in that context was necessary. But I think what you'll find is that despite that, there are many, many instances where the utility did operate just fine under that revenue requirement, which was in some cases substantially less than it insisted at the time of the rate case that it needed. In some cases, utilities actually over-earned under a revenue requirement that was substantially less than what, in the context of the rate case, it insisted was necessary. And I think that kind of shows, that's sort of an example of what I'm saying, is that in the context of a rate case, for a utility to say, we need this, that, and the other thing in order to stay out, I don't know that that's the same decision, again, as the decision it has to make in the future of whether it has to come in. I lastly just wanted to reiterate our objection to the recovery of incremental costs in the RAM and wanted to respond to Attorney Pace's framing of these being government-imposed costs. I think all the utility costs are imposed by the government, right? Like they're under a government requirement to provide safe and reliable service and answer customer phone calls. That doesn't mean that, I think I agree with the suggestion from the chairman that it sounds to us like an exception that follows the rule. Again, I want to reiterate that we believe that there will potentially be incremental costs above and beyond what is necessary in base rates now for these utilities to provide safe and reliable service and to meet the expectations of the regulator. But at some point in history, the utility had to incur those costs as incremental, like as the overall requirements imposed on the utility by the government changed over time. And that's a different thing than the pass-through costs that, from our perspective, should be in the RAM. This isn't a legislatively required contract that the utility incurs expenses on, and ultimately none of those expenses, none of the revenues associated with those expenses flow to the utility's bottom line. These are costs that are entirely in the utility's control. A utility hiring employees, that is a cost that's within the utility's control. That's why FTEs and payroll are a highly litigated part of a base distribution rate case and not a part of the RAM process. So I just wanted to point that out, that from our perspective, I don't think the standard is just because it's a government required or regulatory required cost, that means it should be eligible for RAM recovery. And that's, unless there are any questions, that's all I have.
Just want to explore the but-for sort of analysis. Essentially, too, an investor-owned utility doesn't exist but for the state government issuing it a franchise certificate. Is that understanding correct?
Yes, Vice Chairman, that's exactly what I was trying to say before. I think that's a more pointed way to put it. But yeah, the regulatory compact is itself a sort of government it's an agreement between the government and the utility that has gives and takes both ways. But that's what I meant when I said before, that every cost the utility incurs should be ultimately a government required cost. In fact, if you think about it, if they're incurring costs that aren't required by the government, those shouldn't be recoverable at all, right? So yes, I agree that an investor-owned utility, every cost it incurs it, it meets that but-for standard.
No further questions. Thank you.
Thank you.
Attorney Goodman, anything further?
Yes, we'd just briefly like to address the further positions regarding the recovery of, or the method of recovery of incremental costs. Again, agree with what Attorney Will said in support of recovery through base distribution rates as opposed to the RAM. And we just add that if implementation costs truly are modest, as has been anticipated in the pros final decisions, it shouldn't be burdensome to wait what seems like, I don't know when the next rate case for either utility will be resolved with PBR, but I know that the authority and numerous parties are eager to see that happen as soon as possible. If the incremental costs to implement PBR truly are immaterial, it shouldn't be burdensome to wait some amount of time to reflect them in rates and recover. If those incremental costs really are material in a way that would be truly burdensome for the utilities to endure, which not to be dramatic, but to carry those costs until they can be reflected in rates, then from our perspective, that's just an argument to take another look at how PBR is going to be implemented to see if it should be phased a little differently to reduce that immediate rate impact to customers. But in either event, think that there is likely to be a reasonable amount of regulatory lag that is, for all the reasons that Attorney Will also said, it can be reasonable amount of regulatory lag to wait for those costs to be reflected and recovered through base rates. Thanks.
Thank you. Attorney Rothenberger?
We have nothing further.
Thank you. And Attorney Nigro? Thank you. All right, that brings us to the end of today's oral arguments. I want to thank all of the parties and interveners, not just for your participation today, but for your active engagement throughout the process. We will certainly take under advisement both today's oral arguments as well as the written exceptions and plan to issue a decision in the coming weeks in all three dockets. So thank you, and we are adjourned.